In the previous video, we had a look at two particular cases, that of OUGHTRED and that of Gray, and we talked about those cases in the context of Section 53, subsection 1c of the Law of Property Act 1925. And at the end of that video, I mentioned how lawyers, tax lawyers, were focused on a means of transferring rights in property without the need for signed writing as required under Section 53 1c, and the litigation which probed the perimeters of the rule in Section 53 1c was revolved around the case of Vandervell and the Inland Revenue, and this is what we're going to be looking at in this video. So let me give you some of the background to Vandervell and the case itself. So Tony Vandervell was a successful industrialist, Formula One team owner and philanthropist. And a philanthropist is just someone who donates time, money and or reputation to a charitable cause. And he owned 600,000 ordinary shares, 100,000 A shares and 2.6 million B shares in Vandervell Products Limited. In 1949, Vandervell set up a trust company, that's Vandervell Trustees Limited, and transfers 2 million B shares. These shares are held on trust for the benefit of his children. In 1952, Vandervell transfers 100,000 A shares to his bank to hold as security for payment to be made to his former wife as her divorce settlement. So he transferred shares to the bank as security for the divorce settlement. So he will only get it back once he pays his wife the divorce money. In 1957, Vandervell transfers other assets to the bank to hold as security for the divorce payments. In other words, so the 100,000 shares were no longer being used as security. So he transferred other assets instead of the 100,000 shares. And so the bank then held the 100,000 A shares on bare trust for Vandervell. In 1958, Vandervell decides to found a chair in pharmacology at the Royal College of Surgeons, which requires a gift of £150,000 to be made to the college. So Mr. Vandervell begins with the philanthropic intention to benefit the Royal College of Surgeons. And Vandervell is advised that a tax-efficient way of making the gift would be to transfer the 100,000 A shares held by the bank on bare trust for Vandervell to the college, and then to declare a dividend of £1.50 per share. This would not attract either tax on the payment of the dividends, and as Vandervell would no longer be the beneficial owner of the shares, he would not have to pay estate duty, which is now inheritance tax. So in other words, he is advised to give his 100,000 shares currently held on trust for him by the bank to the Royal College of Surgeons, and this would be tax-free. Given the high rates of taxation at the time, it would not have been tax efficient just to make a gift of money and pay tax on the cash. Therefore, he decides to transfer the shares to the Royal College of Surgeons so that when the annual dividend was paid out to the shareholders, that dividend would be paid in cash to the Royal College of Surgeons in a more tax-efficient way. Vandervell is further advised that if he wants to float Vandervell Limited as a public company, it would be better to have all the shares under his own control. He therefore asks the college, as part of the agreement, to grant an option to repurchase the shares from the college for £5,000. And the college agrees to this, and the shares are transferred, and an option to repurchase is granted to the trustees of the 1949 settlement, that is, the Vandervell Trustees Limited. And the 1958 to 1961 dividends totaling £157,000 after tax are paid to the college on the £100,000 A share. So between those years, those dividends were paid out, totaling that over the £150,000 he was expected to pay. And in 1960, the chair in pharmacology is established and an appointment is made. In 1961, Vandervell and the trustees of the 1949 settlement decide to exercise the option. The trustees pay £5,000 from the Children's Fund to the college. The £100,000 A shares are transferred to their name. And between 1961 and 1965, dividends totaling 1.2 million are paid on the 100,000 shares, now the legal properties of the trustees of the 1949 settlement. In 1965, Vandervell executes a deed transferring his beneficial interest in the shares to be held in trust for his children, and in 1967, Vandervell dies. Okay, so that's quite a lot of facts about the background of Vandervell and his life, especially revolving around this case. But the following points are probably pretty key. So in 1949, we have a trust company, Vandervell Trustees Limited, which was established to hold 2 million shares for Vandervell's children. In 1957, so 8 years later, Vandervell transferred 100,000 shares to the bank to be held on trust for him. It is these shares that are transferred to the Royal College of Surgeons, and therefore these shares which are in contention to begin with. Okay, so the question is, does the transfer of these shares constitute a disposition, as we were talking about in the previous video when we talked about disposition under section 53(1)(c) of the Law of Property Act 1925. However, the option to repurchase was given to Vandervell Trustees Limited, okay, the trustees of the other settlement from 1949. Okay, so really this is the key background points that we have to bear in mind when we look at the case itself. So Vandervell and the IRC 1967. So the Inland Revenue assessed Vandervell as liable for the tax on the shares as he retained a beneficial interest in them. So the Inland Revenue tried to say that Vandervell was liable for the tax on the shares he gave to the Royal College of Surgeons because they argued, in relation to section 53(1)(c) of the Law of Property Act 1925, that Vandervell had failed to divest himself of his equitable interest through this arrangement because he had made a disposition of his equitable interest as a beneficiary of the trust and therefore required signed writing to make that disposition effective. Consequently, it was argued the Vandervell settlement and Mr. Vandervell as a beneficiary retained the equitable interest in the shares, making him liable for taxation. So under the Income Tax Act 1952, section 415, any income from property held in trust which the settler retained any form of beneficial interest was treated as the income of the settler. So if it was found that Vandervell had any form of interest in the shares, he would be personally liable for surtax on the dividends. They argued that when Vandervell instructed in writing the bank to transfer legal title in the A shares to the college, he had failed to specify that he was also transferring his own beneficial title in the shares. So the transfer failed by virtue of section 53(1)(c), and this would have meant that Vandervell was still the beneficial owner and subject to tax, but this argument failed. Okay, so it was held that where a beneficiary directs a trustee to move the entire absolute interest in property, that is both the legal and equitable interest together, to a new trust, there does not need to be a separate disposition under section 53(1)(c), and neither can the beneficiary be said to retain any of the beneficial interest. It was the court's unanimous view that section 53(1)(c) was not intended to cover dealings with the absolute title in property, that is both the legal and equitable together. Rather, it was meant to cover dispositions of the equitable interest alone. Therefore, Vandervell won on the section 53(1)(c) point. And here we've got a little sort of diagram of what's happening, and the three lines represent the three stages in the transaction. So line 1 here on the left hand side, this represents the pre-existing Vandervell settlement on which the shares were held on trust by the bank for the benefit of Mr. Vandervell. Line 2, just over here on the right, represents the instruction given by Mr. Vandervell to the trustees, that is the bank, that his equitable interest should be combined with the legal title, and that both should be transferred to the Royal College of Surgeons. And then we've got line 3, and this represents the eventual transfer of legal and equitable title together. It is this transmission of absolute title in the property which is said to keep this arrangement outside the scope of Section 53(1)(c) because legal and equitable title are passed together. The rationales given for finding that this transfer of legal and equitable title together does not constitute a disposition of the equitable interest does require some attention. Lord Donovan took the view that if one had satisfied the formalities necessary to transfer the legal title, and if the two titles were to pass together, then there should be no further formality necessary. Lord Wilberforce accepted that there was no need to have a separate formality for the transfer of the equitable interest if there's already a clear compliance with the formalities for transferring the legal title, and if both titles were then to pass together. And Lord Wilberforce considered that the purpose of Section 53(1)(c) was merely to prove who held the equitable interest, whereas Simmons in Gray and IRC seemed to consider that compliance with Section 53(1)(c) in itself was required effectively to carry out the disposition of that equitable interest. And we can see what Lord Donovan said here, but I'm not actually going to read this out because it's quite long, but if you want to pause the video and read that out, you can do. But it was held by the House of Lords that if you transfer legal and equitable title together, there is no need to satisfy the formality requirements of Section 53(1)(c). However, the House of Lords still found for the Inland Revenue on the grounds that Vandervell retained a beneficial interest in the option to repurchase the shares under a resulting trust. So to recover the shares, Vandervell created an option to buy the shares back from the Royal College of Surgeons, and this option was given to Vandervell trustees. However, what Vandervell did not do was to explain who was to be the owner of the option to repurchase the shares. So although it was agreed that the trustee company was given the option to repurchase, Vandervell had not successfully divested himself of an equitable interest in the option. Therefore, the court was faced with a situation in which there was an equitable interest in existence without a clear owner. So equity deals with such a situation by holding that the equitable interest returns on resulting trust to its previous owner. And on these facts, that means that the equitable interest in the shares returned to Vandervell on a resulting trust, and he was therefore liable to pay surtax on the option. Okay, and then we had this case, Vandervell's Trust number 2, White and Vandervell's Trustees, 1974. So this case was a claim made by the executors of Vandervell's will against the trustees of the 1949 settlement. So in 1967, Vandervell died and his executors brought an action against Vandervell Trustees Limited, claiming that Vandervell had owned the shares for the period between 1961, when the option was exercised, and 1965, when Vandervell executed the deed transferring the entirety of his equitable interest. The trustee company claimed that the shares should be treated as belonging to the children's settlement. So Vandervell trustees maintain that Vandervell did not own any rights in the shares after the transfer to the Royal College of Surgeons. So the previous House of Lords case, that's the Vandervell and the IRC, had held that the option to repurchase the shares was held on a resulting trust for the benefit of Vandervell until 1961, at which point the option was exercised. The executors claimed that as a result of the House of Lords judgment, the shares repurchased in 1961 using the option were held on trust for Vandervell, and hence formed part of his estate from 1961 to 1965, at which point Vandervell assigned them in writing to his children. So when the trustee company bought the shares back, due to the existence of the resulting trust, this meant the trustee company, according to the executors, held the shares on trust for Vandervell until he signed the deed transferring the entirety of his equitable interest in 1965. During that period, the shares had paid very substantial dividends. If it was found that the shares were held on trust for Vandervell during the period in question, then those dividends would belong to Vandervell's estate and would pass to his residuary beneficiaries, not to his children under the trust. If it was found that the shares did belong to Vandervell in equity, then there would be a substantial tax liability to the estate. the Inland Revenue were awaiting the outcome in the wings, but had been refused permission to be joined to the claim. And so this case, in other words, was brought about by the executors to Vandervell's estate. The executors claimed that, following the House of Lords judgment, Vandervell had a beneficial interest which was not disposed of in writing until Vandervell executed the deed in 1965. Accordingly, he remained the beneficial owner and entitled to the dividends which devolved to his estate on his death. So, because, according to the executors, he still owned the shares between 1961 to 1965, in which time a lot of dividends had accrued, those dividends would belong to his estate and should go to his beneficiaries under his will. The Court of Appeal held that the resulting trust came to an end when the option was exercised in 1961. Lord Denning held that a new trust of the shares rather than the option to repurchase was created, and a trust of the personalty did not require writing under either Section 53(1)(b), as it was not a trust of land, or Section 53(1)(c), as the resulting trust no longer existed. There was no subsisting beneficial interest. So the majority of the Court of Appeal held that when the option was exercised in 1961, a new trust over the shares had been declared. It was also held that as the money used to exercise the purchase came from the 1949 Trust Fund, as a general principle, any property bought with the money under a trust became part of the trust property. The resulting trust, which came into existence as a result of Vandervell's failure to declare on what basis the option was held, was exempt from the provisions of Section 53(1)(c) by provision of Section 53(2) of the Law of Property Act 1925. So this case is really quite controversial. It was held that the grounds on which the Court of Appeal held the shares were held for the benefit of the children were unconvincing and difficult to reconcile with other cases. And a particular issue is actually Lord Denning's separation of the option and the shares as separate properties. However, it has been argued that this is artificial in that the option can be traced into the shares purchased, and that the use of the money from the 1949 settlement will give them an equitable lien over the shares, but not a proprietary interest. Okay, so that I think covers Vandervell, and again, this is a confusing case to many people, as it is a case that is needed and necessary to discuss at the beginning of an equity and trust course. And I always find it quite difficult to explain some of these preliminary concepts and cases when you've only got a basic understanding of some key trust concepts. So this may be a video and a case that you may wish to come back to at the end of your trust course, again, just so that you pick up and understand this case fully. But if you do have any questions at this stage, then please leave a comment below and I'll get straight back to you. Don't forget to subscribe to my channel, and I shall see you next time. Thank you very much for watching.